Folks, welcome to another edition of my video blog. Today's video blog concerns a situation of domestic violence where only the victim and the defendant are available to testify. Many of these cases where there's an allegation that you, Joe Citizen, has assaulted your wife, many times those allegations are unsupported by witnesses. Now, there may be other type of factors involved or evidence. There might be bruising, cuts, bleeding. Yeah, the victim might be hysterical. But oftentimes, because these assaults occur in the home between the husband and the wife, or the boyfriend and girlfriend, oftentimes there are no witnesses to the event other than the alleged defendant and the alleged victim. So how does the state prove its case beyond a reasonable doubt? Can they do it with the victim alone? Well, it depends. Like everything else, it's fact-driven, and your case is going to be very different than the next guy's case, which will be very different than the next guy's case. So yes, a case can be proven by victim testimony alone. However, in my opinion, those are very difficult burdens for the state to meet and to get over that hurdle of proof beyond a reasonable doubt when there's no accompanying circumstantial evidence. So if all you have is a victim, let's say the wife or the girlfriend, complaining that she was pushed or shoved or punched or struck in some manner, i.e. a domestic violence assault, but there's no accompanying bruising, there's no evidence that she had been struck, there's no blood, perhaps the victim isn't hysterical, well, there's always a plausible explanation. Without that circumstantial evidence, it's a very good chance that the victim is making up the story. So these cases are defendable. Just because someone said, you hit me and therefore you committed the crime, doesn't mean they can prove their case beyond a reasonable doubt. And let's be real, oftentimes people may in fact be guilty of the crime. But just as often, what was really just a heated argument between a husband and wife turned into a 911 phone call by the wife, who makes up a story that the husband hit her or struck her in some manner in order to get him out of the house and resolve the argument. We see a lot of that. So if you've been accused of domestic violence, whether there's only the victim accusing you or there are additional witnesses, before you plead guilty, you should absolutely pick up the phone and call my office. These cases need to be sussed out, they need to be litigated, and all the evidence needs to be collected before you ever entertain the thought of pleading guilty. Look at all your options, speak with a qualified defense attorney, and don't plead guilty unless it is a really in your best interest decision to do so. I look forward to bringing you more information on criminal defense on our next video blog. Thank you for joining me. I look forward to seeing you folks soon. Take care. Bye-bye.